Hello, everyone. We're going to do another case. This one is United States v. Carolene Products. So this is about milk, but there's the famous footnote 4 in here, which I'll get to after I'm done reading the entire opinion. The Filled Milk Act of Congress of March 4th, 1923, defines the term filled milk as meaning any milk, cream, or skimmed milk, whether or not condensed or dried, etc., to which has been added or which has been blended or compounded with any fat or oil other than milk fat, so that the resulting product is in imitation or semblance of milk, cream, or skimmed milk, whether or not condensed, dried, etc. It declares that filled milk, as so defined, is an adulterated article of food injurious to the public health, and its sale constitutes a fraud upon the public, and it forbids and penalizes the shipment of such filled milk in interstate commerce. Defendant Defendant was indicted for shipping interstate certain packages of an article described in the indictment as a compound of condensed skimmed milk and coconut oil made in the imitation or semblance of condensed milk or cream, and further characterized by the indictment, in the words of the statute, as an adulterated article of food injurious to the public health. That upon its face, and as supported by judicial knowledge, including facts found in the reports of the congressional committees, the Act is presumptively within the scope of the power to regulate interstate commerce and consistent with due process. Demur to the indictment should have been overruled. It is no valid objection that the prohibition of the Act does not extend to oleomargarine, or other butter substitutes in which vegetable fats or oils replace butter. The statutory characterization of filled milk as injurious to health and as a fraud upon the public may, for the purposes of this case, be considered as a declaration of legislative findings deemed to support the Act as a constitutional exertion of the legislative power, aiding informed judicial review by revealing the rationale of the legislation as do the reports of legislative committees. Reversed. Mr. Justice Stone delivered the opinion of the court. The question for decision is whether the Filled Milk Act of Congress of March 4th, 1923, which prohibits the shipment in interstate commerce of skimmed milk compounded with any fat or oil other than milk fat, so as to resemble milk or cream, transcends the power of Congress to regulate interstate commerce or infringes the Fifth Amendment. Appellee was indicted in the District Court for Southern Illinois for violation of the Act by the shipment in interstate commerce of certain packages of mill nut, a compound of condensed skimmed milk, and coconut oil made in imitation or semblance of condensed milk or cream. The indictment states, in the words of the statute, that mill nut is an adulterated article of food injurious to the public health, and that it is not a prepared food product of the type accepted from the prohibition of the Act. The trial court sustained a demurrer to the indictment on the authority of an earlier case in the same court. The case was brought here on appeal under the Criminal Appeals Act of March 2nd, 1907. The Court of Appeals for the Seventh Circuit has meanwhile, in another case, upheld the Filled Milk Act as an appropriate exercise of the commerce power in Carolene Product Company v. Evaporated Milk Association. Appellee assails the statute as beyond the power of Congress over interstate commerce, and hence an invasion of a field of action said to be reserved to the states by the 10th Amendment. Appellee also complains that the statute denies to it equal protection of the laws and, in violation of the Fifth Amendment, deprives it of its property without due process of law, particularly in that the statute purports to make binding and conclusive upon appellee the legislative declaration that appellee's product is an adulterated article of food injurious to the public health, and its sale constitutes a fraud on the public. First, the power to regulate commerce is the power to prescribe the rule by which commerce is to be governed, and extends to the prohibition of shipments in such commerce. The power is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than are prescribed by the Constitution. Hence, Congress is free to exclude from interstate commerce articles whose use in the states for which they are destined it may reasonably conceive to be injurious to the public health, morals, or welfare, or which contravene the policy of the state of their destination. Such regulation is not a forbidden invasion of state power, either because its motive or its consequence is to restrict the use of articles of commerce within the states of destination, and is not prohibited unless by the Due Process Clause of the Fifth Amendment. And it is no objection to the exertion of the power to regulate interstate commerce that its exercise is attended by the same incidents which attend the exercise of the police power of the states. The prohibition of the shipment of filled milk in interstate commerce is a permissible regulation of commerce, subject only to the restrictions of the Fifth Amendment. Second, the prohibition of shipment of a Appellee's product is in interstate commerce does not infringe the Fifth Amendment. 20 years ago, this court in Hebe Company v. Shaw Hebby Company v. Shaw, held that a state law which forbids the manufacture and sale of a product assumed to be wholesome and nutritive, made of condensed skimmed milk compounded with coconut oil, is not forbidden by the 14th Amendment. The power of the legislature to secure a minimum of particular nutritive elements in a widely used article of food and to protect the public from fraudulent substitutions was not doubted, and the court through that and the court thought that there was ample scope for the legislative judgment that prohibition of the offending article was an appropriate means of preventing injury to the public. We see no persuasive reason for departing from that ruling here, where the Fifth Amendment is concerned, and since none is suggested, we might rest decision wholly on the presumption of constitutionality. But affirmative evidence also sustains the statute. In 20 years, evidence has steadily accumulated of the danger to the public health from the general consumption of foods which have been stripped of elements essential to the maintenance of health. The Filled Milk Act was adopted by Congress after committee hearings, in the course of which eminent scientists and health experts testified. An extensive investigation was made of the commerce in milk compounds in which vegetable oils have been substituted for natural milk fat, and of the effect upon the public health of the use of such compounds as a food substitute for milk. The conclusions drawn from evidence presented at the hearings were embodied in reports of the House Committee on Agriculture and the Senate Committee on Agriculture and Forestry. Both committees concluded, as the statute itself declares, that the use of filled milk as a substitute for pure milk is generally injurious to health and facilitates fraud on the public. There is nothing in the Constitution which compels a legislature, either national or state, to ignore such evidence, nor need it disregard the other evidence which amply supports the conclusions of the congressional committees that the danger is greatly enhanced where an inferior product, like Appellee's, is indistinguishable from a valuable food of almost universal use, thus making fraudulent distribution easy and protection of the consumer difficult. Here, the prohibition of the statute is inoperative unless the product is in imitation or semblance of milk, cream or skimmed milk, whether or not condensed. Whether in such circumstances the public would be adequately protected by the prohibition of false labels and false branding imposed by the Pure Food and Drugs Act, or whether it was necessary to go farther and prohibit a substitute food product thought to be injurious to health if used as a substitute when the two are not distinguishable, was a matter for the legislative judgment and not that of courts. It was upon this ground that the prohibition of the state of the sale of oleomargarine made in imitation of butter was held not to infringe the 14th Amendment in Powell v. Pennsylvania. Appellee raises no valid objection to the present statute by arguing that its prohibition has not been extended to oleomargarine or other butter substitutes in which vegetable fats or oils are substituted for butter fat. The Fifth Amendment has no equal protection clause, and even that of the 14th, applicable only to the states, does not compel their legislatures to prohibit all like evils or none. A legislature may hit at an abuse which it has found, even though it has failed to strike at another. Third, we may assume for present purposes that no pronouncement of a legislature can forestall attack upon the constitutionality of the prohibition which it enacts by applying opprobrious epithets to the prohibited act, and that a statute would deny due process which precluded the disproof in judicial proceedings of all facts which would show or tend to show that a statute depriving the suitor of life, liberty, or property had a rational basis. But such, we think, is not the purpose or construction of the statutory characterization of filled milk as injurious to health and as a fraud upon the public. There is no need to consider it here, as more than a declaration of the legislative findings deemed to support and justify the action taken as a constitutional exertion of the legislative power, aiding informed judicial review, as do the reports of legislative committees, by revealing the rationale of the legislation. Even in the absence of such aids, the existence of facts supporting the legislative judgment is to be presumed. For regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless, in the light of the facts made known or generally assumed, it is of such a character as to preclude the assumption that it rests upon some rational basis within the knowledge and experience of the legislators. The present statutory findings affect appellee no more than the reports of the congressional committees, and since, in the absence of the statutory findings, they would be presumed, their incorporation in the statute is no more prejudicial than surplusage. Where the existence of a rational basis for legislation whose constitutionality is attacked depends upon facts beyond the sphere of judicial notice, such facts may properly be made the subject of judicial inquiry. Borders Farm Products Company v. Baldwin, and the constitutionality of a statute predicated upon the existence of a particular state of facts may be challenged by showing to the court that those facts have ceased to exist. Similarly, we recognize that the constitutionality of a statute, valid on its face, may be assailed by proof of facts tending to show that the statute, as applied to a particular article, is without support in reason because the article, although within the prohibited class, is so different from others of the class as to be without the reason for the prohibition. Though the effect of such proof depends on the relevant circumstances of each case, as for example the administrative difficulty of excluding the article from the regulated class. But by their very nature, such inquiries, where the legislative judgment is drawn in question, must be restricted to the issue whether any state of facts, either known or which could reasonably be assumed, affords support for it. Here, the demurrer challenges the validity of the statute on its face, and it is evident from all the considerations presented to Congress, and those of which we may take judicial notice, that the question is at least debatable whether commerce in filled milk should be left unregulated, or in some measure restricted or wholly prohibited. As that decision was for Congress, neither the finding of a court arrived at by weighing the evidence nor the verdict of a jury can be substituted for it. The prohibition of shipment in interstate commerce of appellee's product, as described in the indictment, is a constitutional exercise of the power to regulate interstate commerce. As the statute is not unconstitutional on its face, the demurrer should have been overruled and the judgment will be reversed. Mr. Justice Black concurs in the result and in all of the opinion except the part marked third. Mr. Justice McReynolds thinks that the judgment should be affirmed. Mr. Justice Cardozo and Mr. Justice Reed took no part in the consideration or decision of this case. Mr. Justice Butler, I concur in the result. Prima facie, the facts alleged in the indictment are sufficient to constitute a violation of the statute, but they are not sufficient conclusively to establish guilt of the accused. At the trial, it may introduce evidence to show that the declaration of the act that the described product is injurious to public health and that the sale of it is a fraud upon the public are without any substantial foundation. The provisions on which the indictment rests should, if possible, be construed to avoid the serious question of constitutionality. If construed to exclude from interstate commerce wholesome food products that demonstrably are neither injurious to health nor calculated to deceive, they are repugnant to the Fifth Amendment. The allegation of the indictment that Milnut is an adulterated article of food injurious to the public health tenders an issue of fact to be determined upon evidence. And then we'll scroll up to the famous footnote 4. So, footnote 4. There may be narrower scope for operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments, which are deemed equally specific when held to be embraced within the 14th. It is unnecessary to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are most other types of legislation. On restrictions upon the right to vote, see, what was that? See Nixon v. Herndon, and Nixon v. Condon. On restraints upon the dissemination of information, see Near v. Minnesota. Let's see. On interferences with political organizations, see Strongberg v. California. As to the prohibition of peaceable assembly, see DeJong v. Oregon. Nor need we inquire whether similar considerations enter into the review of statutes directed at particular religions, Pierce v. Society of Sisters, or national, Meyer v. Nebraska. Whether prejudice, or racial minorities, Nixon v. Herndon. Whether prejudice against discrete and insular minorities may be a special condition which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities, and which may call for a correspondingly more searching judicial inquiry. Well, that was a good read, and as always, if there's any case you'd like me to read, just drop in the comments and we have to take a look. Thank you.